Boy, do I got a good one for you today. How about a good legal debate and some corporal punishment? Before we get started, let's go over the details. Corporal punishment is technically defined as any act causing deliberate physical pain or discomfort to a minor child in response to some undesired behavior by the parent or other legal guardian. It typically takes the form of spanking or slapping a child with an open hand or striking with an implement such as a belt, slipper, cane, hairbrush, paddle, whip, hanger, and can also include shaking, pinching, forced ingestion of substances, or forcing the child to stay in uncomfortable positions. However, it didn't mention making you go out and pick the switch off the tree so she could hit you with it. And if you got too small of a switch, you got hit with it twice, and you had to go get a bigger one. Oh, that was just me. Okay. Wikipedia has a lot of information on this, and I don't even know where to go with that. But in school, corporal punishment was a thing up until a while ago. I can remember when the principal's blinds were drawn, you knew somebody was getting paddled. And our principal didn't mess around. She had holes drilled in her paddle. I got this little colorful graph for you just to show you the schools where corporal punishment is still allowed in the United States. In the red states, it is still legal in public schools. In the blue states, it's not. Could you imagine what would happen today if they paddled a child at school the way they did back a long time ago when I was in school? Yeah, it wouldn't go well. So anyways, this case is an appeal, and he goes over the details pretty much, but he doesn't get into the nitty-gritty. I looked it up a little bit, and it's basically stepdad was handling a lot of the discipline and would spank the child. Dad, who lived in another house, didn't agree with this because the child would come and tell him about it. And so this prompted more actions in the divorce/child custody case. And it got to the point to where they are now appealing it to a higher court. So check this one out.
May it please the court, Richard Beams for the appellant Jennifer Rachel Bradley Odom. This case is about a material change of circumstances and after that, best interest of the child, whereby the court granted the father's petition and changed custody. A great majority, a great deal of the testimony was about corporal punishment by the stepfather, specifically with a belt. There was also an issue about hitting one of the children in the mouth with his hand. The trial court summed that up as hitting the child in question's name is Sadie. She had a half sister named Emma that with the mother. Trial court in its ruling found that Sadie was the one hit in the mouth. We would suggest that's actually not what the testimony showed. It was Emma that got hit in the mouth. But the trial court hinged greatly on this use of corporal punishment. So specifically, when the trial court found the material change of circumstances, there were 5 reasons they found that. The first was the emotional and mental therapeutic needs of Sadie arising out of the use and threatened use of corporal punishment by Mr. and Mrs. Odom, which would be the father, or the mother and the stepfather. The specific corporal punishment is the use of a belt for whippings, as well as a slapping gesture to the hand of the mouth of Sadie, even if slight. As I just said, we would contest that was actually with Emma. As far as the emotional and therapeutic needs of Sadie, we would submit to your honors that that was already being dealt with. One of the main witnesses in this trial the court relied heavily on was Mr. Luke, who was Sadie's therapist. He had been for a while. He actually testified twice. His testimony, especially the second time, was that everything seemed to be going much better with Sadie. Sadie was doing a lot better. The mother was doing a lot better, paying attention to her, taking care of the needs. The mother was also taking care of all the punishment in that home now. And there seemed to be no issue in our minds that the therapeutic needs of the child would continue to be met even if she remained with the mother.
Counsel, I have a question. In your argument, you seem to be focusing on sort of discipline that in terms of an event. There's
Yes,
this
sir.
event that happened. It seems like the trial judge had a concern in terms of a general atmosphere in the home, that there's that Sadie has greater anxiety
Yes, sir.
around her stepfather. Isn't that something that's more continuing in nature rather than a discrete event that's been resolved, that this happened and there's been progress and there's a better way of dealing? And it seemed, and maybe I'm misunderstanding it, you set me straight here, but it seemed like the trial court was finding that there's this ongoing atmosphere where she's just not as comfortable in that house with stepfather for whatever reason. Isn't that part of what's playing into the trial court's thinking here?
Really quick, because I don't like to interrupt, but I had to look this one up, because tell me he does not look like a judge. He looks like he should be sitting on the boardwalk by the beach or something. This is not what a judge looks like in my mind, but I love it. So cool.
I agree. Well, our answer to that would be that when this was first filed, that probably was an issue. By the time we get around to even the first day of trial, that had been resolved. There was an order entered very early on to ban the use of corporal punishment in the mother's home by anyone. And by the time we get around to the first day of trial, the mother is the one handling all of the punishment.
So would it be fair to describe your argument then, counsel, as it was material at one time, but no longer material?
We say, especially based on the case law, it was never material.
Never material.
But the issue that itself had been resolved by the time
What
we got to
about,
trial.
in terms of the anxiety that Judge Usman asked about, what about this notion that the stepfather, rather than engaging in corporal punishment, wielded a belt and walked around the home, not sort of in a threatening manner, not to actually use it? I mean, what about that component of this situation?
We understand that at one time that was ongoing. Again, we would say that was not material, and that any issue that had been happening with that was very early on. It was no longer happening by the time we got to trial. So hopefully that, and I understand both of the questions, because the judge did in fact mention anxiety, as you mentioned, and there were, I want to say, probably 4 or 5 instances of the whipping with a belt. The mouth incident was just one, but I agree with what your honors are saying, that there was an ongoing issue.
In most cases like this, we typically don't have the advantage of some expert testimony where they're actually talking about, in this case we had a therapist talking about the actual impact on the child. Here we do have that, and it seems like to me we should give that a fair amount of weight in a case like this.
I understand, and he was a great witness. We would say specifically by the time the second court date came around, the anxiety, I'm not going to say it was completely gone, but it had been greatly resolved, according to Mr. Luke, that the issues in the mother's home had been resolved, and we no longer had that issue. So that would be our response to that.
You spent a fair amount of your brief arguing about the best interest factors here and
Yes,
how
sir.
they were waived. I mean, it does seem like to me in some instances the court lost track of the site that mother was the primary residential parent. Is that a fair description?
Yes, sir. And that's why we specifically in our argument quoted a case from this court that said that is a very important factor that should be weighed. I believe specifically the trial court found most of the factors to be even, 3 factors for the father, no factors for the mother, but we specifically point out in the brief that, as you said, that should be taken into greater effect per prior cases of the court. Yes, sir. The second reason was the move of the mother into another school district in the midst of the emotional issues. Again, the court did cite the existing emotional issues, but there were a couple of instances in the record where it was already announced that while the mother had moved into another school district, the child herself was never actually moved to that school district. She remained where she was, and they had already reached an agreement where she was not going to be moved. So we would say that should not play a factor in finding a material change of circumstances. C, the mother's failure to grasp the gravity of issues held by Sadie as evidenced by the depressed mood, the crying for no reason, and anxiety. First off, probably not as big of a deal. There wasn't hardly any testimony about Sadie having those issues at the mother's house that was at the father's house. I don't know if the mother even saw that. But I would say specifically, again, I'm going to say this a lot, the second testimony of Mr. Luke seemed to be that issue was gone, that issue had been resolved, the therapy had been going well, the mother and the stepfather had been participating, and that we no longer had that anxiety issue.
Counsel, wasn't the therapist still, though, drawing a distinction in terms of Sadie's sense of her stepfather and comfort level with her stepfather versus her comfort level with at her father's
Yes,
home.
I think so, and specifically with regards to the stepmother, who eventually became stepmother. And I think at one point, Mr. Luke specifically said, though, that could be an issue simply where a child that young is more comfortable with a woman stepmother than with a man who is a stepfather. So I understand what you're saying there, Judge. D, the somewhat dramatic differences in parenting styles between the mother and father, which have evolved after the divorce, which have caused stress and anxiety and went unaddressed by the parties. Looks like he's talking about use of corporal punishment. We would also point out, though, that corporal punishment, admittedly, especially by stepmother, was also used in the father's home. It may not have been with a belt, but he did use corporal punishment. So I would disagree that there even was a dramatic difference in the parenting styles.
And when you say stepmother, in this instance, you're referring to father's, at the time, girlfriend, but now.
And I
so
think
there's, yeah, okay.
Yes, sir. I think that may have actually changed between the first and the second day of the hearings. I believe by the time we got to the second day, she was the actual stepmother. Yeah. So I've had to refer to both in my brief. But we would say that doesn't go to material change of circumstances. And then E, the need for initial and continued therapy for Sadie as a result of the experiences, behavior, and conditions she experienced. Again, there was no issue with anybody that Mr. Luke was going to continue to work with that child. The testimony, we believe, would show that the mother was the one who initiated the therapy with Mr. Luke. So again, we don't see that going to a material change of circumstances. Further, after the court found that, he specifically found that the mother did not engage in any conduct which would be a pattern of emotion, neglect, or substantial non-performance of her parenting responsibilities, the absence or substantial impairment of emotional ties with Sadie, or the abusive use of conflict or any other factor which would require limiting her parenting time with Sadie. Judge McBride, you've already gone to the best interest, so I'm not going to harp on that too long. Our analysis of it was that there were more factors that we think are in favor of the mother, particularly the continuity of care, and that she was the primary residential parent going back to the time of the separation. The case law says that you should only change custody if it's necessary. We would say that this was not necessary, that the issue with corporal punishment was taken care of by a very early court order banning that. The school issue in our mind was a non-issue because the child never actually changed schools, and that Mr. Luke could continue to work with everybody. The therapy was going well. We believe the anxiety had dropped off significantly, especially there's also testimony from Mr. Luke about the relationship evolving between the child and the stepfather. So we think that had improved greatly as well. And we think that when you look at the case law, which we cited about prior cases where there involved corporal use, specifically with a belt, that it did not rise to the level of being a material change of circumstances.
And under the new plan adopted by the court, how many days does mother have now?
I want to say it's around 170, Judge. I believe it was around 240 and 170, something like that. She got an extended weekend, I think, every other week.
Counsel, what about the aspect here of the trial court's concern that mother wasn't picking up on the emotional needs of Sadie with regard to, and maybe I'm misframing that, but it seems like part of the trial court's concern here is that she was having these issues and mom didn't seem to be picking up on it, and then dad had to do so and sort of launch the whole process of getting a lot of these measures that you say are corrected came from dad's objections and concerns about what was going on. How does that play into it in terms of this concern about mom not quite picking up on what Sadie needs? Is that a continuing concern or is that not a continuing concern? If it's not a continuing concern, why not?
Okay, I understand. First off, we don't think it's continuing concern due to Mr. Luke's continued therapy and working with all of the parties to resolve that anxiety. As far as the mother not picking up on it, one thing I would say is mother's a layperson. She may not be able to pick up on cues of a young child as well as most people, and that's where Mr. Luke stepped in and helped her identify the issues that were going on at home. The other thing I would say is that generally speaking, while not cited in my brief, children generally are going to disclose more to the other parent that's going on, I guess I'll say the parent problem's home, than they're going to address directly with the parent. I would say it's quite possible Sadie just didn't want to address or show any of her issues with the stepfather to the mother, whereas she goes to the father, she feels much more open to address any issues she's having with the mother.
Obviously, DCS was involved in this case. Does the record show what services that DCS provided?
I don't believe the record did, and I think mainly they just stepped in to investigate and see what was going on. I don't believe they ever filed a court case to open up a case that we're all generally familiar with. If that's all the questions, then that would be all for me for now.
Thank you.
Yes, sir.
Please the court, I'm Douglas Bates. It's my privilege to represent Mr. Bradley in this case. I'm going to focus mostly on the material change of circumstances and also, with time remaining, the best interest factors. I want to first talk about this issue of corporal punishment. I think the court's questions rightly examine the trial court's reasoning that it was not necessarily a one-time issue and it was not necessarily an issue that was dissolved once and for all. In between the first day of trial and the second trial, the DCS worker was unable to come to court, and so her records were provided into the record. And I stated in my brief what one of the records showed was after there was court involvement, not this present court, but the DCS worker found that the child was complaining that the stepfather was going around threatening the use of the belt, as if I can't use it, but I'm going to threaten it. And so that predated the counselor Adam Luke's involvement. And I think the court put significant weight to see this as a big picture, not an isolated incident. The appellant, I think, wisely tries to, on one hand, say there's no bright line rule about material change of circumstance, and then say, okay, well, here's the bright line rules that have been violated. I don't believe in Tennessee that there's a bright line rule regarding corporal punishment. They cited the Riles case. In response, we cited the Wilson case. And the Wilson case talked about, which is important in this case, the distinction between a step-parent's corporal punishment versus possibly two parents who might use different forms of punishment. Additionally, in the Wilson case, they talked about a stepdad who had, quote, total disregard, unquote, for the express wishes of the natural parent, which is important. I also think in this case...
Well, but in this case, it sounds like mother wasn't opposed to use of corporal punishment, nor father for that matter. They both seem to be some indication they would intervene if they thought it went too far. Is that a fair characterization of the record?
Your Honor, I would state that once the belt was complained of and once the child complained that it was hit in the mouth for complaining about the food, the father never condoned corporal punishment. The stepfather said, if there's not a court order, I'm going to do what I want in my house. The stepfather doubled down on this. I thought the moment of the trial was when he said, I believe if you spare the rod, you spoil the child. He was not going to change his behavior absent court order.
Was that during the April hearing or the subsequent?
The first hearing, Your Honor.
Okay.
And it was clear that the stepfather had an opinion on how to raise a child that was different than both parents. And I believe there's a difference in scope and severity of corporal punishment. And I also think that...
Counsel, isn't there even a narrower aspect of this in terms of rather corporal punishment in general, how this particular child responded to corporal punishment? And the court doesn't have to, does it sort of weigh in on corporal punishment? And it's more an issue of how this particular child was responding to corporal punishment.
That's exactly what I was going to say is corporal punishment, the impact and importance is how it affects the child. Some children could have endured what this child Sadie endured, and there'd be no issues. And Mr. Luke's testimony was very helpful on this in terms of how the child differed in counseling sessions because of COVID. With a lot of the sessions were over Zoom, and the child would be very worried if whether the difference of how it would appear when the child was with the counselor in person. It was worried whether the door was closed, whether anybody could hear on the other side. So whether objectively appropriate or not, what happened to this child mattered to this child. And so for those reasons, we submit that the court wisely identified objectively the corporal punishment might not trigger criminal investigations, but subjectively was a material change of circumstance in this child's life. The second issue that it was not necessarily argued, but I do want to the review in the brief, they talk about Massey Holt being violated when the trial court said, well, a change of school district, even though it's not within the relocation, it's not past the relocation, that it should be not held against the proposed relocating parent. And I would just submit that the trial court did not say in and of itself the change in school districts is the material change of circumstance. Instead, as many things as this child has gone on, adding to it a change of school district, when a parent has a discretion to put the child in either, should not be, the trial court should be allowed to find that as a change of circumstance. I think Massey Holt dealt with what has gone on and to some degree still goes on is when a parent tries to move school districts or out of county and there's a joint decision making in the parenting plan, the non-relocating parent tries to go to court and say you can't do this because of the joint decision making, and Massey Holt deals with that and says that's not what it is. I also briefed it, this might be an opportunity to tweak the Massey Holt's application. Massey Holt came out when the relocation statute was that the relocating parent in a non-equal time had to merely defend that it was a valid reason, that there was not vindictive, and that there was no special needs that would not be addressed in the future home. Massey Holt tried to rectify the problem of it being more difficult to move under 50 miles than more than 50 miles.
But counsel, there's again a narrower basis here, right? In terms of this particular child may have had a need that children in general might not have. So
that's correct. And there's all circumstances, and this one is a perfect place to land that says, here a parent has the ability to take the child into either school districts, either the one it's been in and there was school testimony the child's doing well. It can continue that, and the difficulty getting the child to the morning is measured in seconds and minutes compared to the other school. And so,
how do we look at this sort of change that's happened at mom's house? I mean, when this case started, it seems like the relationship was in a worse place at mom's house for the daughter. And then there have been significant changes in terms of how discipline's happening. There seems to be progress that the expert witness is attesting to. How does that impact both the question of whether there's a material change of circumstance and the best interest analysis in this case?
Your Honor, I think that's a good question. And I think the court, again, applied the totality of the circumstances. There's some cases that talk about if an emergency exists and then it no longer exists, it's no longer a material change of circumstance. This case, I submit, does not present a hard and fast change. The stepfather's testimony was compelling. He wasn't going to change. He doubled down on his approach to parenting was not going to be modified. He might stop the behavior, but what he thinks is best was not going to change. I also think that this is not a situation where, and I think the court found that the mother was unable to stop the environment the stepfather was mandating. Third, the only reason I submit it's gotten better is because of the petition by the father's request, and the continued therapy that Mr. Luke, and I believe the record shows that it was not, Mr. Luke was only reappointed by motion and efforts by the father.
There was a second hearing later on,
Yes, Your
several
Honor.
months after the April 2021, where father asked to reopen proof, and he alleged that Mr. Odom, stepfather, had resumed using corporal punishment. Was that proven or discussed?
It was not It was not admitted through the counselor. We were somewhat hamstrung by what the child spoke with the counselor about. And the child spoke with the counselor about issues that she had observed through her half-sister in the mother's home that were somewhat concerning. And that was addressed through Mr. Luke. There was, I think, I will say this, I think sometimes in trial, counselors sometimes embellish or make an issue that a child might not feel is a big enough issue, but if you take a child to a counselor long enough, it'll become an issue. Here, this counselor did the opposite. The counselor should receive great credit for his work in this case, because I think he presented directly to the trial court where the child was. The child, through the year of counseling with Mr. Luke, the net effect should not be, okay, the child now goes back to the mother and we'll just cross our fingers and hope it doesn't happen again. And so that speaks to the large issue, and that the trial court, in the best interest analysis, is somewhat attacked for applying a nuanced approach that says, okay, there were issues, there was physical issues, there was environmental concerns, but not so much as to apply a limiting factor. And here I would submit that in the best interest analysis, trial courts should be applauded for their nuanced approach to realize it's not like a material change of circumstance, which is just a light switch going on or off. It is a spectrum. And what the trial court did was maximize the mother's parenting time through most of the weekends, and the father.
So how many days does mother have under the new plan?
I submit, Your Honor, I believe it is 140.
140, not 170.
Not 170. It's not close to the 182.5, but it is substantial in nature. Your Honor, those are the points I wanted to address. I'll stand for any questions.
Well, let me just ask you, since you ended off with the best interest factors. I mean, it does seem to me that the trial judge seemed to decide of who the primary residential parent was in weighing the factors here.
Your Honor, if I may address that, I don't believe the mother presented as a stable force that most primary residential parents come into court with. She had moved multiple locations. She'd had multiple people in her home, including one person she had to kick out, a member of her family who was a sex offender. DCS had been in her home. Her husband had created an atmosphere of intimidation. So I think the trial court rightly realized that stability was not the end-all be-all for this child. Something had to change in this child's life. And that is why the court minimized, to the extent it did, the high value court's place on stability. The status quo was not going to help this child succeed in life. And that's why the court entered the ruling it did.
Thank you.
Thank you very much.
I'd just briefly like to address the issue of the sex offender in the home. I think the proof would show in the record that that person was never a member of the mother's home. He was a relative. He was at her brother's house for short periods of time, but he was never a member of the home. Mr. Bates did reference Wilson versus Wilson. We've checked that out. What we would say about that is they do go over step-parent corporal punishment. They say a step-parent should be allowed to punish a child. But when they get to their holding on that, they specifically say the ultimate concern of this court in this case And the issues in this case turns on are the allegations of improper hygiene and negligent health care. So while that court did hit on corporal punishment, that was not one of the overriding themes in that case. The overriding theme in that case was that the mother got medications wrong, the child kept getting sick because of the mother's failure to properly take care of the child and give the proper medication. So we would argue on that point that while they do hit on corporal punishment, that wasn't the main reason they found the material change. It didn't contribute much, if any, at all. I would also like to go specifically to Mr. Luke's testimony on the second time. Specifically, Mr. Luke said the child had recently been as open at the mother's home as she is at the father's. He said that Sadie had not disclosed any new corporal punishment from any of the parents or step-parents. And he also gave an example of something that had recently happened at a session where he said Sadie had forgot a tablet at a great-grandparent's house, and she asked Mr. Odom to go get it for her. And what he said specifically about that example was there was a slight incongruence there, that if you have this level of fearfulness, that you would then ask that person to provide something for you. So I think even Mr. Luke was recognizing that fear and anxiety maybe not was completely gone, but it had greatly diminished between the stepfather and Sadie. So those are the points that I'd like to make. We're ultimately asking you to find that there was no material change of circumstances. If, however, you do, we would argue that the best interest analysis favors the mother and that the primary residential parent shouldn't have been changed and the custody should not have been changed. Thank you, Your Honor.
Thank you. Thank you both.
So there's going to be a lot of different opinions on this subject, whether you are from the school that it's okay to spank a child as long as you're not really hurting them, you're just getting their attention, and the school of there is no reason to put your hands on a child, sit them down, talk to them, put them in timeout, thinking time. We did a lot of thinking time. I don't think they actually thought, though. Not quite sure that worked. Anyways, whatever your preferred method is, you do what works for you and your child. I'm not judging your actions. Just presenting you a very interesting case. So everybody have a fabulous afternoon, and I will be back later with more.